influenced or was influenced by relevant factors and considerations. From the explanation tendered, we are satisfied that the was occasioned by a genuine mistake, which in our view could have been avoided and the members and staff being more diligent when they went to inspect the templates in Athens, Greece, where the printing of ballot papers was undertaken. In the absence of any empirical data, we cannot find a basis upon which to conclude, as a matter of fact or evidence, that postponement affected voter turnout, as a consequence of which the first petitioner alone, as a presidential candidate, suffered disadvantage. At any rate, the nature of the ballot being an individual decision and secret, there may be other factors to which the turnout in the named units can be attributed. From the evidence on record, however, it appears to us that 2022 general election recorded one of the lowest turnouts since the introduction of multi-party political systems some 30 years ago. If there was a low voter turnout, it affected all the 6 categories of candidates, and its explanation, in our view, lies elsewhere, but certainly not a calculated suppression. On the other hand, in rebuttal to these claims, I illustrated with examples to our satisfaction that there was no nexus between the postponement of elections and voter turnout in the affected units. Far from the fact that this claim was undoubtedly just another red herring, it has nothing to do with the question under review, and accordingly we reject it and hold that there is no proof that the postponement resulted in voter suppression to the detriment of the first petitioner. Whether there were unexplainable discrepancies between the votes cast for presidential candidates and other elective positions. Issue number 5. The first petitioner was categorical that there was systemic ballot stuffing in certain counties, mainly in the Rift Valley and central parts of Kenya, where, according to him, a total of 33,208 votes were cast for president only, without corresponding votes for the other elective positions. On the part of IEBC and the chairperson, while acknowledging that indeed in some instances there was vote differential between those cast for president and for other positions, but maintained that they were insignificant, and those instances related to votes by prisoners and citizens in the diaspora who only vote for the president but did not take part in other elective positions. The differential also includes rejected ballot papers and stray votes which do not count as valid votes. The well-established principle that the person who asserts a fact must prove it casts the burden upon the first petitioner to demonstrate that there were instances of ballot stuffing of such a magnitude as to justify the nullification of the presidential election. Ballot stuffing, which is an illegal addition of extra ballots, is a type of electoral fraud aimed at swinging the results of an election towards a particular direction. Not a single document has been presented by the first petitioner to prove systemic ballot stuffing. A figure of 33,208 votes relied on in this claim is based on unproven hypothesis that since the number of votes cast for the president is higher than those for other positions, then, without more, it must follow that there was fraud. we find that fraud is a serious criminal offense and it must be proved beyond reasonable doubt under Section 5N of the Election Offences Act. It is indeed an offense for a person to vote more than once in any election. IEBC has provided a plausible explanation for the vote differential, citing categories of voters who only vote for the president, such as prisoners and Kenyans in the diaspora. There were an insignificant number of stray votes whose combined effects cannot justify nullification of the election. Finally, on this point, a general election in Kenya comprises of 6 different separate elections held concurrently on the same day. Such elections are held by secret ballots, and one cannot predetermine the voter turnout or how voters will vote in each election. None of the parties have flagged anything so significant that it would have affected the outcome of the presidential election vis-a-vis the other 5 elections held on the same day. We find, therefore, there were no unexplainable discrepancies between the votes cast for the presidential candidates and other elected positions. On issue number 6, whether IEBC carried out the verification, tallying, and declaration of results in accordance with Article 138, 3C, and 138, 10 of the Constitution. This issue arises from the printings in all the petitions as consolidated. Based on the sealed pleadings, the affidavits sworn in support thereof, and the written and oral submissions by parties, two viewpoints regarding the meaning, scope, and application of Article 138, 3C, and 10 of the Constitution have been advanced. On the one hand, the petitioners submit that pursuant to the foregoing provisions, the role of verifying and tallying of votes as received from polling stations countrywide is vested in the Commission as a corporate entity and not the chairperson of the Commission. It is their argument that the chairperson cannot undertake this task to the exclusion of other commissioners. They submit that the language of Article 138(3)(c) does not envisage a situation the chairperson can arrogate to himself unfettered authority to verify and tally the results at the National Tallying Center without involving the other commissioners. Such action, they contend, would not only be unconstitutional, but would be sufficient ground without more to nullify an election of a president-elect. In support of their arguments, the petitioners cite the Court of Appeal decision in IEBC versus Maina Kiai and 5 others as affirmed by this court in the case of Raila 2017. The petitioners further submit that Regulation 87(3) of the Election General Regulations is unconstitutional to the extent that it purports to vest the power of verification and tallying in the chairperson of IEBC. On the other hand, the first, second, and third respondents submit that power to verify, tally, and declare results of a presidential election at the National Tallying Center is the exclusive preserve of the chairperson of IEBC. According to them, there is nothing unconstitutional about Regulation 87(3) of the Elections General Regulations. The same regulation the respondents submit makes no mention of commissioners other than the chairperson. At any rate, the respondents argue Article 138(3)(c) of the Constitution does not envisage a situation where it is the commissioners who personally undertake the task of verifying and tallying the results as entered into the thousands of Forms 34A. Such an undertaking would be humanly impossible, they submit. For good measure, the respondents submit that Section 11A of the IEBC Act provides that the chairperson and members of the commission are responsible for the formulation of policies and strategies of the commission and oversight. In their view, the Act does not contemplate a situation where commissioners would be directly involved in the verification and tabulation of presidential election results. The task of verification and tallying, as stated by the respondents, is executed by the staff of the Commission under the direction and supervision of the Commission Secretary, who in turn reports to the chairperson. As to whether the chairperson acted unilaterally in verifying and tallying the presidential election results at the National Tallying Center, the petitioners claim that indeed this is what happened. It is the petitioner's case that the chairperson published an illegal Gazette Notice number 4956 of 2022, in which he designated himself as a presidential returning officer, a position unknown in law and the Constitution. Having done so, the petitioner states that the chairperson proceeded to conduct the verification and tallying process to the exclusion of other commissioners, each of whom he had assigned territorial roles and related to the verification and tallying exercise. On his part, the chairperson of IEBC submitted that although he has exclusive authority to verify and tally the presidential election results as received at the National Tallying Center, he did involve the other commissioners in the exercise before eventually declaring the final results. He submitted that he did this in the spirit of teamwork. The chairperson of IEBC states that indeed the four commissioners were involved in the preparation of the 9th August general election from the time of their swearing into office all the way to the verification and tallying of results at the National Tallying Center until they withdrew from the exercise just when he was set to declare the final results. Having considered all the parties' submissions, we find that pursuant to Article 183C of the Constitution, the power to verify and tally presidential election results as received at the National Tallying Center vests not in the chairperson of IEBC, but in the commission itself. The latter carries out this exercise through its secretariat staff, technical personnel, and any other persons hired for that purpose under the oversight and supervision of the chairperson and the other members of the commission. In line with this court's decision in Raila Amolo Odinga versus Another versus IEBC and two others, as reported in 2017 Kenya Law Report, popularly known as Raila 2017, and the Court of Appeal decision in IEBC versus Maina Kiai, we also find that the chairperson cannot arrogate to himself the power to verify and tally the results of a presidential election through the exclusion of other members of the commission. Indeed, Article 188(10) of the Constitution, although the power to declare the results of a presidential election after verification and tally is vested in the chairperson, he does so only as a delegate of the commission. Consequently, to the extent that Regulation 87(3) of the Elections General Regulation purports to vest the power of verifying and tallying presidential election results as received at the National Tallying Center solely on the chairperson to the exclusion of other members of the commission, the same is contrary to and inconsistent with the provisions of the Constitution. That said, we however take cognizance of the fact that the 4th, 5th, 6th, and 7th respondents are referred to as the 4 commissioners actively participated in the verification and tallying exercise from the beginning up to the and until just before the declaration of the results by the chairperson. They took turns announcing the results as verified and tallied and were present and active during the actual verification and tallying at Bomas. An example is when one of them, Justice Nyangaya, stood on the podium to announce to the public results and also announced an adjustment that had been occasioned by errors of tabulation. The events of 15th August 2022, therefore, came as a surprise. As the public waited for the chairperson of IEBC to declare the final results, sporadic violence broke out at Bomas. The violence swiftly was contained by the security forces, but there was unexpected drama as 2 different factions of the commission began to emerge. Kenyans found themselves watching an appalling split-screen scenario on their television sets. On one part of the screen was the chairperson reading himself to declare the results in accordance with Article 1:810 of the Constitution. On the other part of the screen were the 4 commissioners on the rooms of the Serena Hotel, Nairobi, from where they announced that they would not own the results that were soon to be declared by their chairperson. The 4 commissioners informed the public of their rejection of the yet to be announced results, terming them opaque due to the manner in which the chairperson had been conducting the verification and tallying exercise. In its affidavit dated 25th August 2022, Justice Nyangaya affirmed that the chairperson's actions during the tallying and verification exercise at Bomas made it difficult to ascertain the total number of votes cast and the actual number of votes attained by each candidate, so as to enable him authoritatively state the commission and declared accurate results. All the petitioners have anchored their arguments for the nullification of the 9th August presidential election in Taharia on the walkout from the Bomas by the 4 commissioners. They contend that by rejecting IEBC's results on grounds of opaqueness of the verification and tallying process, they called into question the credibility of the entire election. They further submitted that being in the majority out of the 7-member commission, their view should prevail and the election should be nullified. It is the petitioner's argument, therefore, that a dysfunctional commission cannot deliver a credible election. We note that apart from their 11th-hour denunciation of the verification and tallying process and their arguments regarding the conduct of the chairperson, the 4 commissioners have not placed before this court any information or documents showing that the elections were either compromised or that the result would have substantially differed from that declared by the chairperson. Critically, they have not explained why they participated in a verification process when they knew that it was opaque up until the last minute. Indeed, at the Serena Hotel press briefing, the 4 commissioners acknowledged that thus far the entire election had been managed efficiently and credibly. The chairperson on his part did not make matters any better by maintaining a stoic silence, even as things appeared to be falling apart. All this, in our view, points to a serious malaise in the governance of an institution entrusted with one of the monumental tasks of midwifing our democracy.